Test, 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 1, 2, 3.
Good morning. A quorum being present, the subcommittee will come to order. I want to welcome everyone to today's subcommittee hearing, and I'd like to thank our panel of witnesses and our members for joining today's discussion about the economic benefits of reforming outdated, costly, and burdensome regulations that are having a negative impact on American businesses, large and small, and the work of Congress, this committee, and the administration since the beginning of last year. Despite the significant improvements to the economy, thanks to regulatory reform and Republican-led tax reform efforts, more work is needed to build on this success. We still have 6.3 million Americans out of work, and we cannot afford to stop looking for ways to improve economic conditions and support American workers. Burdensome federal regulations on businesses of all sizes are one major obstacle that hurt the efforts and slow the ability of businesses to grow and hire talented employees. Small business owners alone are spending at least $12,000 every year complying with regulations. Additionally, in 2013, businesses both large and small devoted $94.8 billion to hiring full-time personnel to achieve regulatory compliance. The costs associated with regulatory compliance are creating a major barrier to a business's ability to not only hire more workers, but it's hampering the ability for these businesses to grow as a whole. To make matters worse, despite the pleas from business owners around the country, the Obama administration continued to issue new, complicated, and onerous regulations that slowed economic progress during a time when the economy was focused on recovering from the 2008 financial crisis. Republicans actually listened to the needs of businesses large and small, and that is why congressional Republicans and the Trump administration have made regulatory reform a priority. During this Congress alone, House Republicans have led the charge in delivering regulatory relief by advancing 15 resolutions of disapproval under the Congressional Review Act to eliminate some of the most costly, redundant, and unnecessary regulations. I'm proud to say that 5 of the 15 CRA resolutions that were signed into law by President Trump came from the Committee on Education and the Workforce. Since the passage of the initial 15 CRA resolutions, we have already started to see a reversal in the truly negative effects of Obama-era regulations. According to the American Action Forum, which our witness, Dr. Douglas Holtz-Eakin, is president of, overturning these 15 regulations achieved approximately $4 billion in total cost savings to the private sector. Additionally, the Committee on Education and the Workforce has held 22 oversight hearings on federal rules and regulations, and I'm proud to say 8 of those hearings were conducted by this subcommittee. This record is proof members of this committee, as well as the staff, remain committed to taking a hard look at regulations and how they impact employees and employers. After 8 years of lost opportunity under the Obama administration, this committee and the Congress are now able to work constructively with the Trump administration to improve the regulatory environment. For example, early in his administration, the President issued executive orders to reduce the number of regulations and control regulatory costs. Employers are taking notice of Congress and the administration's actions to remove regulatory burdens. A survey conducted by Little Mendelsohn stated that a little over a year into the new administration, employers are cautiously anticipating less impact from key regulatory issues on their workplaces over the next 12 months. As the Trump administration continues to reform the regulatory process, employers anticipate additional economic growth. Not all regulations are bad, but today's hearing will explore the benefits of responsible regulatory reform, how regulatory costs can be controlled to allow for the continued growth of the nation's economy, and the importance of Congress and the administration continuing to collaborate on a regulatory reform agenda. Our panel of witnesses today are well suited to discuss this subject, and I look forward to hearing their thoughts as well as their ideas about where this committee should look for future reform efforts. I now yield to the subcommittee ranking member, Mr. Takano, for his opening remarks. Mr. Takano.
Thank you, Mr. Chairman, for holding this hearing today. I think it is imperative that we have a discussion on the impact of President Trump's reckless anti-regulatory agenda on working people. On day one, President Trump promised to stand up for America's workers, saying the forgotten men and women of our country will be forgotten no longer. However, right out of the gate, the Trump administration rolled out an ideological, anti-regulatory agenda that has negatively affected already struggling workers. The Trump administration's efforts to delay, weaken, or roll back Department of Labor regulations with assistance from congressional Republicans puts anti-regulatory ideology ahead of efforts to protect workers from lost pay, preventable workplace accidents, and continued discrimination in the workplace. Now, for example, the Trump administration's refusal to defend the Obama-era fix to the outdated overtime rules costs workers $1.2 billion every year. $1.2 billion that our workers are not getting. I introduced the Restoring Overtime Pay Act, H.R. 4505, to codify the Obama-era rule, which would have made 4.2 million more workers newly eligible for overtime pay, strengthened the overtime rights of an additional 8.9 million workers, and raised the share of the salaried workforce that is eligible for overtime from less than 7% to a little more than 30%. The Trump administration's anti-regulation agenda is also putting the health and safety of workers, including children, at risk. At a time when an average of 150 workers die from on-the-job injuries and illnesses every day, the administration is planning to relax rules that prevent 16 and 17-year-olds from performing dangerous work, including roofing and work using chainsaws and wood chippers. The Trump administration has also undermined efforts to promote equal pay for equal work by stalling the EEO-1 pay data rule designed to help identify patterns of pay discrimination. It seems the Trump administration is willing to go to great lengths to push through its anti-worker deregulatory agenda, even breaking rules already in place. According to reports, the Labor Department hid legally required estimates that showed its proposal would cost workers billions in lost income. Reports indicate that this was directed by Secretary Acosta, who lobbied the Office of Management and Budget Director, Mick Mulvaney, to let the proposal go through without the required estimates. The Trump administration's decision to bury these estimates calls into question its commitment to a process that is fair and transparent. In truth, claims that regulations are job killers and deregulation boosts job growth are just scare tactics used by wealthy special interests to divide Americans and convince workers to settle for less than they deserve. Now, the Obama administration, which President Trump and congressional Republicans accused of implementing burdensome regulations, oversaw 75 consecutive months of job growth, the longest streak of total job growth on record. In fact, the pace of job growth has actually slowed since President Trump assumed office. In 2017, there were 2.188 million jobs created, lower job growth during any of President Obama's last 4 years in office. During the last 12 months of the Trump administration, from May 2017 to April 2018, the economy has added an average of 190,000 jobs each month. That's lower than the monthly average of 208,000 jobs during President Obama's last 12 months in office. Anti-regulatory rhetoric only creates an even greater divide between the wealthy few and working-class Americans. We do not have to choose between an economy that is strong and an economy that treats workers with dignity and respect. Committee Democrats believe that protecting workers from being killed on the job and ensuring that workers earn a fair wage for their work are basic principles that nearly all Americans share. We want to offer Americans a better deal, and we have proposed a national paid family leave program, rules to ensure fair work schedules, and smart policies that will grow wages. I thank the witnesses for joining us here today, and I yield back the balance of my time.
Thank you, Mr. Takano. Pursuant to Committee Rule 7C, all subcommittee members will be permitted to submit written statements to be included in the permanent hearing record. Without objection, the hearing record will remain open for 14 days to allow statements, questions for the record, and other extraneous material referenced during the hearing to be submitted in the official hearing record. It is now my pleasure to introduce today's witnesses. Dr. Douglas Holtz-Aiken is president of the American Action Forum here in Washington, D.C. Mr. Ryan Odendahl is president of Quest Group of Perrysburg, Ohio, and is testifying on behalf of Associated Builders and Contractors, Inc. Dr. Heidi Shearholtz, did I say that right? Good. I'm always trying to make sure. With a name like Byrne, people get that messed up, so I appreciate that we got that one right. She is the senior economist and director of policy at the Economic Policy Institute. And Dr. Karen Harned is executive director of the National Federation of Independent Business Small Business Legal Center here in Washington, D.C. All right, I will now ask our witnesses to raise your right hand. Do you solemnly swear or affirm the testimony you are about to give will be the truth, the whole truth, and nothing but the truth? Let the record reflect the witnesses answered in the affirmative. Before I recognize you to provide your testimony, let me briefly explain our lighting system. You each will have 5 minutes to present your testimony. When you begin, the light in front of you will turn green. When 1 minute is left, the light will turn yellow. When your time has expired, the light will turn red. Now, bang, bang, Maxwell Silverhammer isn't going to come down right at that moment, but that does mean it's time to wrap up as quickly as you can. And I may say something to you to try to get you to move along a little bit quicker, but we don't try to be too harsh about that. After you have testified, members will each have 5 minutes to ask their questions. All right, we will start and recognize for 5 minutes Dr. Holtz-Aiken for your comments.
Thank you, Mr. Chairman, Ranking Member Takano, and members of the committee for the privilege of being here today. It is certainly the case that the Trump administration has charted a different regulatory course than did the Obama administration. During the 8 years of the Obama administration, it finalized a costly rule at an average rate of 1.1 per day, with a total self-reported cost of compliance for the private sector of $890 billion, or more than $110 billion in stealth tax increases during the course of those 8 years. And I have little reason to doubt that that contributed to the sluggish recovery from the Great Recession. In contrast, from his inauguration to the end of fiscal year 2017, the Trump administration actually cut the regulatory burden by $900 million in executive agencies and overall added only about $6 billion, including the independent agencies. It's a completely different approach to the regulatory burden. Even more importantly, beginning in fiscal 2018, the Office of Management and Budget's Office of Information and Regulatory Affairs has given the 24 regulatory entities in the United States regulatory budgets that they must adhere to for additional compliance costs imposed on the private sector. This is an important step, completely different and unprecedented in our history, and it has also imposed on the agencies a unified measure of how to measure the cost of regulation so that you can make comparisons across the agencies. All of this, I would say, is a dramatic step forward in the conduct of regulatory affairs and the issuing of regulations. The same can be said for workplace regulations, and there are 4 that stand out, at least to me, that I'll mention briefly. The first would be the overtime rule. The Obama administration issued the overtime rule that, in the end, affected about 900,000 workers who regularly worked overtime, raised their pay by about 2%. These are numbers that the Congressional Budget Office put together, but cost private enterprises about $1 billion a year in order to comply and get their payroll systems up to snuff. So that's the kind of regulation that really doesn't pass a benefit cost test and has been reversed going forward. There was also a joint employer decision that was done in the NLRB. Its future is not clear, but there was an administrative interpretation at the Department of Labor, which moved from a direct control standard to a direct or indirect, leaving a lot of ambiguity, potential litigation, and costs for employers. This administrative interpretation has also been reversed. That unwinds, in part, some tremendous damage, in particular in the franchise industry, which is most deeply affected by this, and which was the fastest source of job growth in the recovery, and where the issuance of these joint employer decisions actually visibly slowed the franchise employment growth. Third on my list would be the independent contractor administrative interpretation, assuming that an employer relationship. This has the biggest impact on the so-called gig economy. As I mentioned in my written statement, there's a lot of evidence that this was an extraordinarily rapidly growing segment of the U.S. economy. It has an enormous amount of innovation. It has tremendous heterogeneity in the nature of the customer and worker relationships. Given that we really don't understand its future path and the implications of regulating it as if it was a 1950 employer-employee relationship, this is a place where regulatory forbearance is in order, and the Trump administration has done just exactly that. I think that's the right path on that one. And the final one that I would mention is the so-called blacklisting rule, the Fair Pay and Safe Workplace rule, which would have imposed enormous compliance costs for federal contractors, especially onerous on small businesses, and where the reversal will improve not just the procurement process, but also the business lives of anyone helping to assist the federal government. So I think this is an important first step to have a more sensible approach to regulation. I think it's going to benefit the economy. We're already seeing some of the impacts of that to date, and I look forward to answering any further questions you might have.
Thank you, Dr. Holtz-Aiken. I now recognize Mr. Odendahl for 5 minutes.
Chairman Byrne, Ranking Member Takano, and members of the subcommittee, thank you for the opportunity to be with you today to discuss the important issues facing our nation's workforce. My name is Ryan Odendahl, and I'm the president of Quest Group, a civil and environmental merit shop construction firm based in Perrysburg, Ohio. I also serve as the chairman of the Associated Builders and Contractors ABC National Safety Committee. Today's hearing focuses on the need for regulatory reform to further unleash economic opportunity in the United States. Providing a safe workplace that supports the health and wellness of employees is vital to a productive and efficient workforce that increases our industry's economic impact. It is also undeniably the right thing to do. My company and many employers in the construction industry work diligently to ensure the safety of our workforce, and I believe we share this concern with our federal agencies. While enforcing the law and ensuring that bad actors are held accountable for their actions is necessary, it's my experience that our federal agencies work most effectively when they collaborate with our employers to focus on proven, data-driven, and common-sense measures that support safe workplaces and effectively reduce the rates of injury, illness, and fatalities. The welfare of our workforce is best preserved by promoting best practices and genuine leadership to establish a culture of safety in the workplace. My entire organization is committing to upholding the stellar safety requirements that are also espoused by ABC. At Quest Group, we have a saying with respect to our safety program that safety excellence requires shared participation and shared responsibility. And I'm proud to state, extremely proud to state, that our employees have worked over 2 million person hours without a lost time incident. Our sustained performance can be attributed to a vigorous safety culture that engages associates throughout the organization with an understanding that safety excellence and the welfare of our team members requires that each person, every person, has a responsibility to be a safety leader. Through our membership with ABC, we also participate in the association's Safety Training Evaluation, or STEP process. Established in 1989, STEP serves as a benchmarking and improvement tool for achieving world-class safety performance in construction. Members measure their safety processes and policies on 20 key components through a detailed questionnaire and learn to enhance and implement additional safety programs. The best performing ABC STEP participants, the diamond level participants, have been shown to have workplaces far safer than the industry average, with an 85% reduction in total recordable incident rates, making them 670% safer than industry average. Leaders in our industry are striving to drive a culture of accident prevention. And I believe that all accidents are preventable, and the right leadership and culture that invests in employee safety education and engagement will lead to safer projects, increased economic output, and success in our industry. While it's my firm belief that most agency professionals share this view, we're all subject to the changing priorities of different administrations. In its worst form, counterproductive methods can place a greater value on excessive fines and enforcements used to shame companies into compliance than they do preventative measures. As a U.S. Marine, I was trained to lead from the front, and this philosophy feels very much like leading from behind. The collective goal of zero harm can best be achieved as a collaborative effort between regulators and industry professionals. Burdensome and confusing obligations on our employers often do nothing to improve job site safety, but instead stifle our workforce and ignore insightful input from our industry experts. Congress and this administration have already taken important steps towards correcting the workplace safety culture, including this committee's important work to repeal the controversial Volks rule. Our companies and industry experts, I firmly believe, are anxious to share their valuable experiences to promote workplace safety. In this spirit, OSHA currently has a panel review process under SUBREFA that allows for the agency to meet with representatives of directly regulated small entities and offers an opportunity to provide advice and recommendations on regulatory alternatives to minimize the burden on small entities. These panel reviews can provide valuable insight from top safety experts in our business communities and help guide the development of workable regulations that will lead to the improvement of workplace safety throughout the country. I applaud this committee for its work to address these critical issues facing our workforce today, and sincerely thank you for the opportunity for being invited to speak on this panel. I look forward to answering any question that the members may have.
Thank you, Mr. Odendahl. Dr. Sherholz, you're recognized for 5 minutes.
Thank you. Thank you, Chairman Byrne, Ranking Member Takano, and other distinguished members of the committee. My name is Heidi Sherholz, and I'm the Director of Policy at the Economic Policy Institute here in D.C., and prior to joining EPI early in 2017, I was the Chief Economist at the U.S. Department of Labor, where I worked on many workplace protection regulations. So the backdrop to this conversation here today is very heated rhetoric attacking regulations as being too costly and costing jobs. And it's a pretty strange backdrop because it's completely at odds with the evidence on the effect of regulations. The weight of the evidence, the weight of the research shows that federal regulations don't just protect workers, consumers, and public health, they also provide overall net benefits, so benefits minus costs to the economy. For example, the Office of Management and Budget found that during the Obama administration, the estimated annual net benefit of major regulations was over $100 billion per year, which is not a surprise given that federal regulations go through an extremely rigorous vetting process, and they're implemented because they are smart for the economy and they're smart for the people in it. Further, the evidence shows that regulations have very little effect on the net number of jobs in the economy. The editors of a recent collection of essays on the impact on jobs, of regulations on jobs sum up their findings in this way, quote, "Regulation plays relatively little role in affecting the aggregate number of jobs in the United States. Studies generally find either no strong relationship at all or relatively modest effects of regulation on employment." Perhaps notably, conservative researchers at George Mason University have also thrown cold water on the notion that federal regulations are a drag on the economy, finding in a 2014 report that, quote, "Federal regulation has little to no effect on declining dynamism in the U.S. economy." But despite this evidence, the Trump administration has engaged in an unprecedented attack on regulations, raising risks for workers while rewarding companies that put their employees' health, safety, and paychecks at risk. Some key examples include rolling back a rule that required employers to keep accurate records of workplace injuries and illnesses for 5 years, giving employers a get-out-of-jail-free card when they fail to keep crucial workplace safety records. Proposing to roll back some provisions of a rule protecting workers from exposure to beryllium in the construction and shipyard sectors. Taking money out of workers' pockets by abandoning the 2016 overtime pay rule, which would have provided new overtime pay protections to more than 4 million workers, providing affected workers with more pay while working fewer overtime hours. Rolling back a transparency rule that would allow workers to know when their employer had hired an outside union-busting firm during a union election. Rolling back the Fair Pay and Safe Workplaces rule, which would have helped ensure that lucrative federal contracts and taxpayer dollars are not awarded to companies with track records of egregious labor and employment law violations. proposing a rule that would make it legal for employers to take workers' tips. This proposal actually had an unexpected outcome when the department faced great pressure to come to the table to hammer out a compromise, which they did, following revelations that they had conducted the required cost-benefit analysis for that rule, but then buried it when it showed that the rule would have been terrible for workers if implemented. And then finally, the administration is gearing up to do more damage with, for example, a plan in the spring regulatory agenda to propose to make it easier for 16 and 17-year-olds to work in hazardous occupations. And I'll just end by noting that while job growth has been strong for the last 7.5 years, including notably during the period of implementation of many of the regulations that the Trump administration has abandoned or rolled back, wage growth remains weak for most workers and inequality is rising. These wage trends also cannot be attributed to regulation. They began in the 1970s. They worsened substantially during the Reagan and Bush years. In fact, since the 1970s, real wages for typical workers basically only grew during a very brief period late in the Bill Clinton administration. Weak wage growth over the last 4 decades was the result of a policy onslaught over that period to shift economic leverage from workers to employers. If the Trump administration and majorities in Congress were truly looking for policies to unleash economic opportunity for all and not just the already affluent, they would not spend their time painting regulations as the problem while dismantling key worker protections. They would instead tackle policies that would actually lead to broadly shared prosperity, including policies to strengthen, not gut, rules that support good jobs. Thank you, and I look forward to your questions.
Thank you, Dr. Sherholtz. Ms. Harner, you're recognized for 5 minutes.
Thank you, Chairman Byrne and Ranking Member Takano. On behalf of the National Federation of Independent Business, thank you for inviting me to testify today regarding the economic opportunity that employers and workers can realize through regulatory reform. Overzealous regulation is a continuous concern for small business, and the uncertainty caused by the future of regulation prevents small businesses from growing, from raising wages, and from hiring employees. In a small business poll on regulations, NFIB found that almost half of the small businesses that were surveyed viewed regulations as a very serious or somewhat serious problem. So it is not surprising to learn that America's small businesses have welcomed President Trump's commitment to rolling back unnecessarily burdensome and duplicative regulation. In fact, small business optimism is at its highest level in decades, according to NFIB's monthly Small Business Economic Trends Survey, due in large part to this deregulatory agenda. But in addition to deregulation, compliance assistance has also been very important to the small business owner, because the small business owner often is the chief compliance officer for his or her business. As a result, NFIB is encouraged by the Department of Labor's apparent shift to more robust compliance assistance programming. For example, small business owners and other members of the regulated community have been pleased to hear that the Wage and Hour Division at the Department of Labor will once again issue opinion letters. When a small business owner has a question about how a law applies to his business, they can ask DOL for an opinion letter. In this way, the agency provides that business with fact-specific guidance on how that rule will work for their business, what they need to do to comply. And that just is invaluable for the small business owner who is looking for an answer of what is and is not permitted under the law. More recently, on April 3rd, the Department of Labor launched its Payroll Audit Independent Determination, or PAID program. This is a 6-month pilot program for employers and employees to resolve Fair Labor Standards Act disputes. Under the program, employers conduct self-audits of their payroll. If they discover overtime or minimum wage violations, they self-report those violations to the Wage and Hour Division. Employers then work with the agency to correct their mistakes and quickly provide any back wages due to affected employees. PAID aims to resolve wage and hour claims expeditiously and without litigation. to improve employers' compliance with the FLSA and to ensure that more employees legally due back wages receive them faster. Congress also has provided significant regulatory relief by rejecting 16 burdensome regulations using its authority under the Congressional Review Act. With the CRA, Congress assures the regulated community that each of these problematic regulations will not be reproposed by later administrations without significant substantive revision, unless, of course, Congress passes a law that specifically allows the agency to do just that. In particular, NFI appreciates Chairman Burns' leadership last year by sponsoring and pushing for enactment of H.J. Res. 83, which repealed what is commonly known as the Volks Rule. That rule, promulgated by the Occupational Safety and Health Administration, extended to 5 years the time in which the agency could cite employers for record-keeping violations. Small businesses would have been hit particularly hard by this rule, and we truly appreciate your leadership, Mr. Chairman, on repealing it. NFIB commends the House of Representatives also for your diligent work in passing several regulatory reforms, including H.R. 5, the Regulatory Accountability Act. Contained in that, Title III, the Small Business Regulatory Flexibility Improvements Act, is particularly important to the small business constituency I represent. Of note, we support reforms that would require every agency to comply with the Small Business Regulatory Enforcement Fairness Act, or SUBREFA. That would require agencies to convene small business advocacy review panels like the ones that Mr. Odendahl referenced before every economically significant rule is promulgated, and also reforms that would account for the indirect cost of regulation on small business and provide for judicial review of Regulatory Flexibility Act compliance during the proposed rule stage. NFIB applauds the subcommittee for highlighting the importance of regulatory reform to employers and employees alike, and I appreciate you having me testify today and look forward to your questions.
Thank you, Ms. Harnett. Excellent opening statements. We appreciate each one of you. We're going to start with our members' questioning. Our first question or time is going to come from the chairwoman of the full committee, the gentlewoman from North Carolina, Dr. Fox, who's recognized for 5 minutes.
Thank you, Mr. Chairman, for convening this hearing, and I want to thank our witnesses today for excellent presentations. Mr. Odendahl, thank you for taking time away from your business to travel here today to share your perspective on the impact of federal regulations. It's inspiring to hear about the safety culture within your company. You mentioned in your testimony the importance of practical application of safety regulations. I actually hear this all the time from people in my district. Can you expand upon how OSHA can create regulations that translate easily and clearly to the job site? If there's any progress that OSHA has made recently in this regard, and can OSHA be doing more in this area?
Chairwoman Fox, thank you so much for that question. It's my belief that OSHA can create regulations that translate to the job site by partnering with industry. The collaborative effort by partnering with industry and industry experts who really want to help. We want to help create better regulations, more workable regulations. The production of guidance documents on regulations is hugely impactful for business. Frequently asked questions for regulations, existing and proposed, is fantastic. Any assistance with implementation and compliance that OSHA can provide is very good.
Thank you. I, again, hear this from employers in my district all the time. Rather than a got you kind of an attitude, it is, how can we work together? Because I know no employer that doesn't want their workers to be very safe. Ms. Harnett, I understand that NFIB's Small Business Optimism Index recently achieved a record high level for small business owners. This would seem to indicate small businesses are responding to the positive direction our economy is headed. As it relates to regulatory reform, can you speak about what policies are making small business owners so optimistic and what can be done to ensure the optimism continues, or on the other hand, what sort of policies would stop this confidence in its tracks?
Right. So we actually, obviously the tax bill has been huge, and that definitely plays a role. But prior to the enactment of that, we saw the optimism index go up considerably and the concern about regulations go down considerably. For the small businesses I represent, it's really the death by 10,000 cuts, if you will, when you're looking at the regulatory environment. And so over the last, or 7 years prior to Trump's administration, they didn't know what was coming next. And you would talk to them and they literally were concerned about moving forward because they didn't know what next mandate out of Washington was going to come down the pike. So I really think that alleviating that stress has made a lot of difference.
Thank you very much. Dr. Holtz-Aiken, as you and the chairman have said, this committee worked very hard on Congressional Review Act pieces of legislation, and as the chairman pointed out, we're very proud to have passed 5 of the 15 CRAs that were signed by President Trump, and I was able to sponsor a successful resolution in another committee that overturned the regulations, which gave unelected bureaucrats the inappropriate ability to blacklist federal contractors. A recent report from you said that these resolutions resulted in $4 billion in total cost savings. Could you provide examples of how workers, employers, and the economy at large benefited by Congress and the president taking such immediate action?
Well, I think this is very important action. I congratulate the Congress and this committee in particular for doing it. Imposing the cost of a regulation doesn't mean there's more money for the business to comply, and so that has to come from somewhere. It's going to come from their capital budgets, which will hurt the productivity of workers. It could come from the wage growth of employees, and so they'd be hurt from that. Everyone will benefit from having a regulatory burden that is imposed in a more intelligent and disciplined fashion, and that's what the aggregate would show. That's what shows up in examination of, for example, impacts on manufacturing, where $1 billion in regulatory costs harm labor by about 3%. That's what shows up in state-level experience with regulatory moratoria, where the regulatory moratoria yields faster growth in economic activity and in the labor force in particular. So I think these steps are very important first steps, and there's much more that can be done to improve the regulatory environment.
Thank you again. I yield back, Mr. Chairman.
Thank you, Dr. Fox. The chair now recognizes the ranking member, Mr. Takano, for 5 minutes.
Thank you, Mr. Chairman. In Trump's economy, workers are seeing weak wage growth. While some employers complain about the burden of regulations, I think it is important to talk about the positive impact regulations can have on workers. Workers like Wanda, who worked as a store manager at Dollar General for over a decade. Her salary as an exempt employee was around $37,000 per year. She worked 50 to 70 hours per week, never receiving pay for the time worked above 40 hours a week. Now, much of this time was heavy lifting, literally heavy lifting, working the cash register or unloading freight, none of which sounds like management tasks to me. Overtime rules are like minimum wage protection for the middle class. They guarantee that employees are paid for their work, and if their labor is so valuable that their employer needs them for more than 40 hours a week, they should be paid for their experience and their skill by those employers. Over time, employers figured out how to outgame the system, and they figured out how to get around overtime pay. So the Obama administration moved to update the rule. If this update had gone into effect, Wanda would have seen an increase in her pay or a decrease in hours worked while receiving the same pay. However, the Trump administration failed to defend the Obama-era fix that would have raised the share of the salaried workforce eligible for overtime from less than 7% to nearly 33%. and give workers like Wanda stronger protections. Now, Ms. Sherholtz, Ms. Harned's testimony highlights an example of an employer that pays his managers $30,000 a year. Based on the available data, is $30,000 the hallmark of a truly managerial position when compared to other jobs in the economy?
Thank you for the question. I think that's a really important point, because it is absolutely true that a manager, a bona fide manager, could be paid $30,000. But that is just one portion of overtime protections. The idea of overtime protections is to protect workers, including managers, from being exploited. So workers who may not have the leverage vis-a-vis their employers to not have to work long hours for very low pay. So that's the difference here. A salary threshold at $30,000 would mean that you had perhaps managers or other workers who weren't managers, but their employer called them managers, who do not have the leverage to not be taken advantage of from their employer being exempt from overtime.
Yeah, so let's kind of make it more clear. What does the anecdotal and empirical evidence tell us about quote-unquote managers at many fast food restaurants?
So the managers at many, particularly frontline supervisors of fast food restaurant workers, many of those workers, they may have some managerial tasks that they have to do, some managerial duties, but they're extremely low paid and may have to work for very long hours for very low pay. So it's not a set of workers that has a lot of leverage.
So it's not, I mean, do they generally meet the duties test in order to be exempt from overtime pay requirements?
In some cases they do, and in some cases they don't. In some cases that they do. But the key is that a salary of $30,000 does not indicate that they are in a position of bargaining power with respect to their employer, that they are not being taken advantage of.
So they could in fact meet the letter of the duties test. But here's the thing I want most Americans to understand who are watching this hearing, is that you can be given this title of manager, be paid $30,000 a year, but because you're a manager and you somehow meet these duties tests, you can be made to work long hours, way over 40 hours a week, and you have no leverage with respect to your employer and able to get your working conditions, your pay increased. Yeah. So that's what the overtime rule was designed to get at. And this is a category of worker, potentially big category. Back in 1970, we had it so that 70% of the workforce, or near about that, 69% of the workforce was eligible for overtime pay because of the way we had structured the duties test, the way we had set the threshold. Now it's less than 10% of the economy. 10% of salaried workers are qualified, and that's what we need to get at. And this is what the president failed. He failed to listen to, failed to address the concerns of this segment of our economy. Anyway, I yield back, Mr. Chairman.
Thank you, Mr. Takano. I now recognize myself for 5 minutes. Dr. Holtz-Aiken, in your testimony, you noted that the Obama administration created an additional $890 billion in new regulatory compliance costs for business owners, and you rightly refer to that as a stealth tax increase. But you heard Ms. Sherholtz's testimony, which said basically regulation benefits the economy. Maybe we could get this down to a level where I can understand it. What's the difference to the average American worker, between the Trump administration approach to regulatory policy and the Obama administration approach to regulatory policy?
I think the fundamental difference is that the Trump administration has a very disciplined approach, characterized by these regulatory budgets, that says, yes, we want regulations that have net benefits, but let's make the costs as small as possible so that the net benefits are as large as possible. Let's work with businesses and ask them what is the easiest way to reach the objective, and as a result impose the least harm on the economy. That's a fundamental difference from simply issuing regulation after regulation.
But if I'm the employee, how do the business benefits because it's got less costs. I'm the employee, how do I benefit?
The fundamental challenge in the U.S. economy that's been mentioned already today is to get faster growth in the wages for the middle class. In 2016, those households that worked full-time for the full year saw exactly 0 increase in their real income. That's unacceptable. And the fastest route to sustained increases in the standard of living is to have better productivity. That comes from allowing firms to innovate in business models. It comes from allowing them to invest in capital, train their workers. All of that takes money. Reducing the regulatory costs is part of a recipe for better growth.
Thank you. Mr. Odendahl, I'm going to ask you a question that may seem kind of silly. Is it good for your business to have somebody injured on the job?
Chairman, thank you for the question. Absolutely not. It's not good for anyone to have a worker injured on the job, and that's the shared goal that we have with our regulators, both business and the regulator community, to keep our employees safe, to keep our workers safe, whether they're my employees, whether they're an employee on a project that I drove by on the road today. We have the obligation to keep those folks safe. That can best be done together, collaboratively, again, but the costs, not only the human cost is the largest cost of an employee hurt on a job site, you know, the impact to their family, the impact to their ability to earn a living, but it's the larger impact being the human cost. But in today's business world, it's just should go unsaid that harming a worker at the workplace is the wrong thing to do.
Well, it's wrong. I understand what you're saying. It's wrong morally. It's also stupid economically.
Yes, sir.
Because it interferes with the productivity of your business. So you have every business interest, every economic interest to do what you can to provide a safe workplace for your workers. Is that correct?
Yes, sir.
Appreciate that. Ms. Harnett, we just heard a lot about overtime. That regulation, which was a massive overreach, ended up in a November 2016 federal district court opinion that ruled that the Obama administration Labor Department actually exceeded its statutory authority under the Fair Labor Standards Act when it promulgated that. As you know, lawmaking is under the purview of Congress, not a regulatory agency. What is the Trump administration doing differently in this regard, and what could be done to better ensure future administrations do not exceed their authority under the laws as they promulgate regulations?
Well, I do think the administration is being careful in its deregulatory agenda as far as it's going back through the processes that are set forth in the Administrative Procedures Act on rules that the agencies want to roll back. So it's not just, striking them from the books with no notice and comment. I would also say that we do, Secretary Acosta has been very open about his commitment to the rule of law and leaving legislating to the legislators and not the regulators. We agree with that. Small business owners do not have lobbyists roaming the halls of Congress. They're working in their businesses in Ohio or wherever it might be, and their only real chance for a voice when these big policy decisions are being made are to come to you. They're not going to be at DOL making their case.
Well, I thank you for that, and I oftentimes think when we deal with these problems up here, maybe we need to have some of your members up here right by our side so they can say, wait a minute, you need to think about what you're doing and what it's going to do to me and what I can do for my employees by what you're harming my business with. Okay, I will yield back, and at this point, I will recognize the gentleman from New Jersey, Mr. Norcross, for 5 minutes.
Thank you, Chairman. By the way, small business was in to see me twice yesterday, the Food Council, so they have plenty of their voices spoken. I hear them each and every day, and more importantly, I hear them when I go home. So the idea that people don't have a voice, I think, is certainly not actually true. Dr. Holtzig, the net benefit rule that you keep talking about, the cost-benefit rule, when a regulation is being considered, let's talk about safety regulation, what is the figure they use for the loss of a human life?
I don't recall off the top of my head. I'm happy to get that to you.
You have no idea?
Not today. There have been times in my life when I knew that number, but there are two different ones used in the federal regulatory process.
If the cost of a human life was more than a net benefit, does that mean we shouldn't impose that rule?
So the rule should be...
So if you lose money, if the rule will cause a company to lose money because somebody died, according to your net benefit statement, that we should impose that rule.
You should impose the rule if the value of lives saved is greater than the costs of imposing the rule. And that's how the rule is implemented.
Oh, so it's okay to kill people if there's a net benefit?
The goal is never to kill people. I
No,
think that's
but
quite clear.
you're saying if it's too expensive, we shouldn't put a rule in that it's okay then for those people to be lost because it was too expensive. That's the logic that you're trying to get us to believe. And the point I'm trying to make, sir, is that the loss of a human life isn't a calculation of dollars and cents. It's your colleague to your left, what he spoke about. That's the human family that's left behind. And I've been on those jobs 3 times where somebody was lost. And apparently people making rules seem to think that it's okay. That small businesses, because they're small, shouldn't have to play by the same rules. That's false. Doesn't matter if you're a one-man business or a 1,000-person business. The loss of a human life is intolerable. And I think we need to remember the human side of this equation when we start talking about net benefits. Because it's not all good or it's all bad. But when it comes to the human side of this, that's what we're forgetting. How much money we're making, but we're losing people at the same time. Construction industry, one of the most dangerous occupations. If we go back 2 dozen years and the amount of people who were lost per day on the job site, it was much higher than it is today. And the one reason that happened was these rules, these costly burdens. Yeah, they cost a little bit of money, but everybody should come home from the job. And I just urge everybody here today to remember that side of the equation. It's not all dollars in the pocket. It's the human lives. I yield back.
Thank you, Mr. Norcross. The chair now recognizes the gentleman from Wisconsin, Mr. Grothman, for 5 minutes.
One of the frustrating things I find in society, it seems over time, even though the GDP goes up, so you'd think America's becoming a wealthier country, it doesn't seem it's any easier for people back home to afford a house or take time off or whatever. I'd like to ask anyone, and you should all know the answer to this question, when we impose new regulations, and those new regulations may mean, you know, building some new a farm, having to build a new manure pit, or a business having to hire more people to fill out government forms. What effect does that have on GDP?
I can take that. I mean, what we know is that we can look at what the OMB has shown for for regulations that we've seen, and that the benefits outweigh the costs of regulations, like from 2010.
Well, I don't think you're getting the point of the question. If a business has to hire 15 more people, or whatever, 15 more people to fill out government forms so the government can monitor this or that, maybe the cost to the business is $1.5 million, right? It says $100,000 an employee, let's say, including so the GDP goes up by $1.5 million, right? But does that mean that the wealth of society goes up by $1.5 million? And I think the answer is obviously no, correct? Anybody?
If I could, I think it shows up in 2 very important ways. We know that the route to sustained increases in the prosperity of Americans is productivity growth. And we had terrible productivity growth for 6 years now in the U.S. economy. That's because of the myriad things that businesses do not have money to do in training workers, investing, starting new business models. It also shows up in how much things cost. So imagine the most regulated thing in the world, which is the American home, and how much more costly it is because of the things that have to be done. It shows up at both ends, what they make and what they pay.
Right. I think the point I'm going to try to make to you, because you're not quite getting it, is that if we hire more people to build cars or to build highways, we have become a wealthier society, clearly, because we're building more things. If we hire more people to fill out government paperwork, we have not become a wealthier society, but when the economists calculate GDP, they both count the same way. So in the last 30 years in our country, if we have hired a lot more people to fill out paperwork or government employees to process that paperwork, we have not really become a wealthier society, though economists would say we have driven up GDP, correct? And maybe that's one of the reasons why it doesn't seem like it's any easier to live the American dream today than 30 years ago. I'll give you all another question because you're all here to talk about regulation. I think if we were in this room 10 years ago, I think most businesses would feel we were overregulated. Most businesses could give examples of regulations that seem to completely lack common sense. Are there any regulations that anybody in this room can say that we have gotten rid of that were in effect, say, in 2008 that are not around today? Could you give me any examples of that? And I think everybody would agree if you talked to business in 2008, they could all give you a blizzard of things they were having to do that completely lack common sense. Can anybody give me any examples of any regulations that have disappeared in the last 10 years? Or disappeared that were in effect, say, in 2008? Yeah,
I know of only one.
Oh, you know,
which is,
bingo, great.
during the Obama administration, the rule was changed so that you no longer had to wear a hazmat suit to clean up a milk spill on a commercial dairy farm.
Good. There's one. I don't think that was probably widespread, affects a relatively small number of people, but great. In other words, once a regulation goes into effect, it almost never goes the other way. It's forever and ever a burden and drain on the American economy. I'll give you Miss woman on the end there.
Started, yeah.
Yes. It's sometimes said that regulation hurts small businesses at the expense of big business. In other words, the more regulations, the more our economy gets taken over by multinational corporations because the little guy doesn't have the lawyers on site to process everything. Could you elaborate on that? Was one of the goals of the people who want more regulations to try to have everybody work for a big multinational conglomerate and drive all the little guy out or force them all to be bought out? Do you think that's one of the real reasons for more regulation? Because I think frequently I find big businesses.
Unfortunately, Mr. Grothman, she's going to have to give you that in writing afterwards because your time is over. So the chair will now recognize Mr. Scott, the distinguished ranking member of the full committee, for 5 minutes.
Thank you, Mr. Chairman. I want to thank our witnesses for being here. We've been talking about jobs, and we had a recent tax cut, $1.5 trillion. After you add interest, it'll run up a cost of $1.9 trillion. Mr. Holtz-Eakin, I've seen estimates of 350,000 jobs created, maybe as many as 900,000. Is that what you've seen in terms of estimates for the jobs that will be created by that tax cut?
I think the CBO put the number at somewhere around 900,000, and then there's about $1.2 trillion in additional wages in this year's baseline compared to last year's. Both are in part attributed to the tax bill.
Okay, now, the estimate for jobs per billion, if you're building roads, bridges, and infrastructure, is approximately 15,000 per billion. Is that right?
Ballpark.
So that for 100 billion, you should be able to do 1.5 million jobs.
I would encourage everyone to not measure things solely in terms of jobs. The reality is that the U.S. economy is very close to full employment, if not at full employment. Its capacity to actually create jobs will be limited by the growth in the labor force. The beneficial impact of better regulatory, better tax, and other policies will show up largely in additional wages going forward, not in the creation of new positions.
Was that a yes, about 1.5 million jobs for 100 billion?
I don't think we're going to get rapid growth in jobs, is my point. We've done the growing we can do by getting people back to work. Now we need to grow in a different way by having everyone who's working be more productive.
And just multiplying that out, if you had 500 billion, I think the chairman put up a chart that says only 6.3 million people out of work. you can hire for half a trillion. You run out, I think you're pointing out, you run out of people before you ran out of money. We spent 1.5 trillion, where a third of that you could get many times, well, for less than a tenth of that, you could have many more, multiple numbers of jobs. That would also affect wages and everything else, because if everybody's got a job, if you want people, you got to pay more. Ms. Sherholtz, when you do a rule, you have to do an analysis, is that right? Yep. What goes into that analysis?
Sorry? A key thing for the analysis is for an economically significant rule, you have to quantify the cost, the economic impacts of that rule to the extent possible. So that's the key. You need to be able to give the public what they need to know in order to assess the merits of that rule during the public comment period. So a really comprehensive assessment of the economic impact is what's required.
And that would be the cost to businesses, the cost to the public, and the benefits to everybody.
Yep, that's right.
Can you tell me how this worked out in the TIP rule that was pending?
So the TIP rule was an interesting case. It was a requirement as part of that rulemaking process for DOL to fully, comprehensively estimate the economic impact. We know from really good investigative reporting that they actually did that. They estimated the economic impact, found it would be really bad for workers, and so instead of showing that analysis, which is what they were required to do, they instead buried that analysis. So it was a really subversion of the rules of the rulemaking process.
Mr. Chairman, I think we might want to have a hearing to find out what happened to that analysis, because it doesn't seem like things went the way they should go, and I would recommend that we kind of consider that as a committee. But in the meanwhile, could you tell me what, in terms of what goes into the analysis, it's just not jobs and dollars, worker safety, safe environment, public health, are those part of the analysis?
Absolutely. It's just quantifying all the economic impacts to the extent possible. So, for example, in the overtime rule, which we've talked about a great deal here, it's not just the additional money that newly affected workers will get, it's also the savings, the time savings that they get. They wouldn't just get money, they would be working fewer hours for free. That would have an impact on work-life balance, have an impact on productivity, can have an impact on worker health. So really, there's a requirement to be as comprehensive as possible in the analysis.
Thank you, Mr. Scott. The chair now recognizes the gentlewoman from Georgia, Ms. Handel, for 5 minutes.
Thank you, Mr. Chairman, and thank you to all of our witnesses here today. I appreciate your time. I wanted to start with Dr. Holtz-Aiken. It's good to see you. Following along Representative Grothman's point about the fact that regulations get passed and then they're layered and layered and layered, and rarely do they go away. And sometimes I think there is a false choice set up where we are choosing between having less regulation and worker safety, and I don't think the two are mutually exclusive. But I wondered what advice you might be able to give to us as lawmakers as we consider ways to strengthen protections through smarter policies, but also ways that we can make sure that the regulatory climate keeps pace with what the realities are in the workplace. Is that getting to sunsets, a more robust cost-benefit analysis? How might we be able to tackle that?
So I thank you, I think, for stressing the false choice that's often presented between safety and regulation. The goal is to provide that safety at the least cost to the economy as a whole. And there are ways to improve the regulatory process to do that. A good first step, I think, was the Trump administration's decision to put out regulatory budgets, which in effect put the discipline into agencies to say, well, we need to do this. Is there an existing regulation that no longer serves a valuable purpose that we can get rid of?
Can you just go a little bit deeper in what that actually means for the folks watching this?
So
they're given a regulatory budget and then they do what?
Has been explained. When you issue a regulation, you have to do an economic impact analysis, which identifies the costs of that regulation in as comprehensive fashion as feasible. In the past, you simply just kept adding them. Now, if you want to add $500 million in costs to the Department of Labor, Department of Interior, whatever it may be, if your regulatory budget for that year is exhausted, you can't add any more costs. You have to get rid of something else to make room for that $500 million. And that is a process that will discipline both in the kinds of new regulations that are issued. They will have to be the least costly possible, and providing incentives to go back and review existing regulation to see if they're still genuinely serving their original purpose, or can they be, that burden be relieved. And I think both are very important steps that have been taken at OMB. The Congress could move further and actually codify this. It could take on the job of saying, okay, we need to have a smarter regulatory state. We're going to pass legislation requiring that of all agencies, including independent agencies. I'd recommend that. I think that would be a very valuable thing.
Great. All right. Thank you. To Mr. Odendahl, on that issue of false choice, do you believe you have to choose between a reasonable regulatory climate and worker safety?
Thank you for the question. I don't believe that those two are mutually exclusive. I think regulations that are common sense and practical and implementable by contractors, combined with support from the agencies, I think everyone wins. It's that collaborative effort that we try to get to the goal together faster. We're seeing things right now from OSHA that lead to that goal. The safety stand-down earlier this month that focused on fall protection was extremely well put together. Very well done. The trench safety partnership that OSHA announced with stakeholders in North Dakota for excavation safety. The OSHA Alliance program and the new on-site consultation programs, that is very refreshing for us to see. So I think that those two can go hand in hand for the betterment of our business and our economy and our employees.
Great, thank you very much. And to Ms. Harnett, you mentioned in your comments the Department of Labor's sort of new philosophy in being more supportive, and Mr. Odendahl did as well, in issuing opinion letters and FAQs and guidance. Can you share with us what additional steps might be able to be taken to be a little more collaborative? Because I think we all want the same things. We want a common sense climate, but we also want worker safety. Quickly.
Right. Well, those are two very positive steps, and I just think the answer is more of it. For example, under the George W. Bush administration, there was a program with the Occupational Safety and Health Administration that was a compliance program where you could get certified that your business was safe, and we actually had several members, and our members are not big. I mean, our average member has 5 employees or fewer, but we had several members that spoke positively about that program.
Super. Thank you. Mr. Chairman, I yield back.
Thank you, Ms. Handel. The chair now recognizes the distinguished gentlewoman from North Carolina, my fellow co-chair of the HBCU caucus, Ms. Adams, for 5 minutes.
Thank you, Chairman Byrne, Ranking Member Takano, for convening this hearing, and to the witnesses, thank you for your testimony as well. I want to question something that is repeated in Dr. Holtz-Eakin's testimony, the notion that deregulation creates wage growth. I touch on this because when I hear this idea, I always ask myself one question: for whom does deregulation cause wage growth? Dr. Holtz-Eakin cites multiple times in his testimony the assertion that deregulation creates strong wage growth. The Trump administration has clearly been busy in deregulating our workplaces and the financial industry. So does the data show corresponding wage growth as a result?
No, right now what we are seeing is we're seeing strong job growth, which we have been seeing for the last 7.5 years, but wage growth remains very tepid. Wages are growing slowly, inequality is rising. That's not the fault of regulation, it's the fault of an onslaught of policies over the last 4.5 decades that have shifted leverage away from workers.
Okay. Another thing I want to highlight is that there are still structural inequities in our economy as it relates to wages. Women on average make 80 cents for every dollar men make, while for women of color, the numbers are 63 cents on the dollar for African American women and 54 cents on the dollar for Hispanic women compared to white men. So, Dr. Sherholz, in 2016, EEOC issued an update to the EEO-1 pay data collection form. The goal was to empower our enforcement agencies with enhanced tools that will be better able to address discrimination in the workplace. Opponents criticized these updates as being overly burdensome, even though we had an employer testify before this committee and assert that she collected more detailed information than the 2016 update to the EEO-1 form required. The Trump administration has since put these updates on hold. So what is the impact of rolling back these updates on working women and minorities?
Those updates would have been really, really important for identifying pay discrimination, being able to root it out. Not updating those right now is a real problem because it goes against what we know are the dynamics out there, that many of these disparities are not getting better. Like, even if you control for education, age, geography, et cetera, the women make less than men, black workers make less than white workers, and in particular for the racial wage gap, they have not improved. They have actually deteriorated a little bit over the last 40 years. There's a real problem in our economy with these inequities. This kind of pay data collection would have allowed people to figure out where that's going on and do something about it. So putting it on hold will just keep that kind of discrimination in the dark.
Okay, to follow up, the Trump administration has failed to defend the 2016 overtime rule, which would have raised the wages of salaried workers, 1 in 3 of who are African Americans and make up 8.9% of the salaried workforce, but 12% of workers directly benefiting from the rule. Hispanics make up 11.8%, but 16% of directly benefiting workers. The administration has proposed allowing employers to steal workers' tips, with women bearing 80% of the cost. Factoring in the rollback of EEO-1, can you speak quickly to what the Trump administration's regulatory agenda would do for women and minority wage growth?
So I guess the backdrop there is that women and minorities are more likely to be at the low end of the wage distribution. These labor standards are more likely, disproportionately provide leverage to people at the low end of the wage distribution. So this kind of attack on these regulations, really, it's not a stretch to say it really is an attack on the wages of women and minorities in the economy.
Thank you very much. I yield back, Mr. Chair.
Thank you, Ms. Adams. The chair now recognizes the gentlewoman from New York, Ms. Stefanik, for 5 minutes.
Thank you, Mr. Chairman, and thank you to our witnesses for being here today. Dr. Holtz-Eakin, the previous administration engaged in sub-regulatory actions, that is, actions that were taken through a much less formal process than traditional rulemaking. And while these actions may not be formal regulations, to many workers and employers and small businesses, they have as large of an impact. The Labor Department Wage and Hour Division engaged in this practice with 2 administrator interpretations, one clarifying who qualifies as an independent contractor, and the other broadly interpreting joint employment. Could you please expand upon the impact sub-regulatory actions have on employers and small businesses, and why an agency would issue them rather than engaging in notice and comment rulemaking like the traditional regulatory process?
Well, certainly on the latter, I think on the merits, you should go through the full process. It's a quicker process to just do the sub-regulatory guidance, the administrative interpretation. The economic impact is the same. If you have to comply with this, it will have the same impact on the economy. The broad impacts of the joint employer rule were visible and profoundly negative. In work we've done, we saw, for example, a marked slowdown in what had previously been rapid growth in hotel employment and the pay in those areas did a U-turn after the joint employer decisions. The franchise model as a whole was deeply impacted, and that had been the most rapidly growing source of employment during the recovery. What can an administration do about that? Well, you can issue new administrative interpretation, or in some cases, with the Congressional Review Act, the Congress has, for example, with the CFPB auto lending rule, undone that sub-regulatory guidance. So in both cases, you unwind the economic damage of a harmful regulation.
Thanks. My second question, which is also for you, is if you look at the Bureau of Labor Statistics April 2018 Employment Situation Report, manufacturing employment has risen over 245,000 over the previous 12-month period. Can you point to specific examples of how regulatory reform has helped manufacturers achieve this growth?
I think more important than any particular regulatory reform is the fact that manufacturing lies at the intersection of so many of the agency's activities, and what we did see for 8 years during the Obama administration is every agency issuing new regulations at an extraordinarily high and costly rate, as I indicated in my opening statement. And so to stop that in and of itself has had dramatic impacts on not just small business confidence, which we've seen in the NFIB surveys, but also in CEO confidence in the manufacturing sector. So there's a signal there that that kind of pace will not continue. And then there's the actual relief they got from Congressional Review Act resolutions, and the fact that some of overtime rules and things which have been stopped, the DOL is going to reformulate that rule. Where there was overreach, they're going to take care of it. So the combination, I think, is a bigger impact than any single piece of regulatory reform.
Yeah, I appreciate that. I mean, in my district in upstate New York, I represent about 40% of the geography of New York State. It's one of the largest districts on the East Coast. And I've been to hundreds of small businesses, of manufacturers. That's one of my favorite parts of this job. And to a business, to a manufacturer, they consistently raise the cost of regulations in terms of hampering their ability to create jobs. So this is an important issue. We will continue to work on regulatory reform and continue to build on this economic growth we've seen over the past year. Thank you very much. I yield back.
Thank you, Mr. Stefanik. We now call on Mr. Desaulniers for 5 minutes.
Thank you, Mr. Chairman. Dr. Sherholtz, there's been an assertion today by one of your fellow panelists that regulatory compliance cost has an effect on industry employment. Do you care to comment on that? Is there good empirical, non-subjective research in that regard?
Yeah, there's actually a lot of research looking at the effect of regulations on employment, and what it finds is that regulations don't have an effect on the aggregate level of employment. And that word aggregate is actually really important here because it actually can have an effect. There can be some churn underneath. So for example, you do a regulation that outlaws lead paint because that is, it's a serious condition that can be fatal, particularly for kids. And so you actually see job loss in the lead paint industry, but then you see job gains in the industries where alternatives to lead paint are created. And so the overall number of jobs is not affected, and that is actually what the sort of weight of the evidence shows. And in fact, if you look at Dr. Holtz-Eakin's testimony, he doesn't actually claim that regulations hurt the overall, federal regulations hurt the overall number of jobs. He shows that increase in federal compliance costs can reduce industry-level employment, which I just talked about. Yes, that can happen, but doesn't make the claim that it reduces overall number of jobs.
So I want to associate myself with the comments from my colleague on the other side of the aisle from Georgia. It frustrates me as a former small business person and a former Republican. I wouldn't be here if I didn't change parties 20 years ago because I was frustrated representing a county that has 4 refineries, multiple chemical plants. A lot of people look at the Bay Area as being just high-tech. In Contra Costa and Alameda County, we're the workhorse of Northern California. Those 4 refineries contribute 25% of the fuel sold in California. Having been a Pete Wilson, a Republican governor appointee twice, we did robust cost benefits when we did regulation either in Cal OSHA or at Cal EPA. So I just had a meeting with our building trades who were here a few weeks ago. And in the Bay Area and in Contra Costa County, those 4 refineries are, by your standards, I think, Mr. Holtz-Eakin, pretty vigorously regulated. We passed something called the Industrial Safety Ordinance. We worked with the refineries. And the reason was, one of the refineries, and as you know, the product there is very regulated, so it's pretty much a commodity. They fight to hit the spot market. Well, one of the 4 was very aggressive, and we lost 5 lives in multiple incidents. We were losing lots of workers to injuries. One of the other companies, that is a multinational corporation, their lobbyist called me and said, if you don't do something as a regulator, we're going to have to compete with them because the market, He's getting 20% after-tax profits, and we can't do that and do what you want us to do and we want to do. So we implemented that ordinance. 20 years later, they're amongst the most profitable refineries. Just had a meeting with the vice president of Chevron, and he said, you know, we fought you like heck, but we were happy to work with you. The Carpenters Union has 7,000 apprentices waiting to go in. In the plumbers and the electricians, they have more people waiting to go in. We have academies that this committee has talked about where young people in a very poor part of the Bay Area, Richmond, California, can go in an apprenticeship program and know that they're going to get a job at Chevron at $75,000 a year. So a lot of your funders criticize California and the Bay Area for this regulatory environment. Back to my comments from my friend from Georgia is, I wish, knowing that we're going to have subjective opinions because of our perspectives, and Mr. Holt-Seekins, to be perfectly honest, your funders, and the funders of the opposition research, it really would be wonderful if the Congress could have more of this discussion about what is truly effective for all of our constituent groups. Because my work experience, you can do that. To the point, Ms. Handel, it's not mutually exclusive. So, Mr. Holt-Seekins, could you speak to that? It would be wonderful if we could get groups like your group and the Koch brothers to have a functional conversation about, and the American Petroleum Institute, which I understand is a funder of your organization, to both talk about policy and politics the way we used to, at least in my remembrance between the two parties, about what works, knowing that we're going to have subjective opinions. But it seems to me, and this is my perspective, that, and it may be from reading books like Dark Money and Democracy in Chains, we've gone to this ideological perspective, at least from the right, that the least amount of regulation is what works the best. And in my life experience, that's not accurate.
So I'll confess my confusion at some of the things you've said.
Those
aren't my funders, and I have no idea where you got that information.
I got it from the web. So it may be an assertion.
You almost certainly did not. That's just not true.
Oh, okay, well, I just did it, so I'll show it to you. But I will
American
take it.
Action Forum.
Yeah, that's what I Googled. Who are your largest funders?
I'm a 501c3. We don't disclose our funders. We never have. But I can tell you with complete honesty, all the names you mentioned are wrong.
Well,
and I don't know where you would get that.
I will show it to you after the hearing. And
the second thing I would say is that everything I've said here today is my opinion alone, and I believe it fully. And I am not a voice for any funder.
And I hate to interrupt that conversation, but your time is up, Mr. Desaulniers.
Thank you, Mr. Chairman. Happy to have the discussion.
I would like to thank all of our witnesses for your superb testimony and for the fact that you took time out of your very busy schedules to be here today to testify for the subcommittee. Mr. Takano, do you have any closing remarks?
Yes, Mr. Chairman, thank you for holding this hearing today. And I just want to remark that while on the campaign trail, President Trump promised that he would stand up for workers. He would be working people's weapon in combating a system that was rigged against them. This hearing today shared the reality of the Trump economy with all those watching. Trump's economy favors corporate America at the expense of the same workers who voted for him. The Trump economy makes it more dangerous to go to work, and it guarantees that workers won't share in the prosperity that the Obama years built. Instead of investing in jobs, President Trump and congressional Republicans pushed through a huge tax cut for the wealthy and for corporations. Instead of strengthening rules that protect workers, the Trump administration pushed through an anti-worker, anti-regulatory agenda. The administration has demonstrated that they're willing to break rules and hide data that shows how harmful their actions are, and all in the furtherance of their anti-regulation ideology. Today, our colleagues called this hearing to praise Trump for rolling back, delaying, and weakening labor and employment regulations. They have been willing participants in this plan, nullifying regulations using the Congressional Review Act. But what they won't mention is that these regulatory rollbacks mean that workers are less safe at work. These regulatory delays make it harder for workers to be assured of equal pay for equal work. And these weakened standards make it harder for Americans to make ends meet. A clear example of this is the Trump administration's refusal to defend the rule that would have made 4.2 million more workers newly eligible for overtime pay. 4.2 million more workers. It would have strengthened the overtime rights of an additional 8.9 million workers. Overtime protections are the minimum wage for the middle class. Abandoning this rule shows us that Trump is not looking out for workers. The rhetoric around deregulation presents us with a false choice. A false choice between regulations that help workers and economic growth. This really isn't an either-or situation. We can have both an economy that is strong and an economy that is fair. I thank the witnesses for joining us here today, and I yield the remainder of my time back.
Thank you, Mr. Takano. Well, this has been a very interesting discussion, and I appreciate the candor that everybody brought to it. I remember almost, in fact, 40 years ago when I took administrative law in law school, when I learned the undergirding theory for why we have administrative regulations. And it kind of made sense. There are times when the Congress can't get too far down in the weeds in some of these things, and we delegate our legislative authority to regulatory agencies under very defined limits about what they can and can't do. And then we entrust them to take that legislative authority we've delegated to them, and they go out and get into the weeds and regulate on things like worker safety and making sure that people aren't discriminated against in the workplace, which 99% of Americans all agree with those premises. But somewhere between when I took administrative law and today, we've not just had regulatory creep, we've had regulatory gallop. And part of that is the nature of government bureaucracies. If you're a hammer, everything looks like a nail. If you're a regulator, everybody looks like they got to be regulated. And if they're already regulated, we got to regulate them some more. I'll give you a great example. I also took banking law in law school. And back then, and I actually did some of this in my law practice, you had the FDIC that would actually do the regulation of consumer lending for state chartered banks, and the Comptroller of the Currency would do it for national chartered banks. All these consumer regulations we've had out there for many years, truth in lending, et cetera. And I can tell you from representing banks and going through there, when the bank examiners would show up, pretty rigorous examination, pretty rigorous things that they got to comply with. Well, we didn't think that was enough, so we came up with something called the Consumer Financial Protection Board, CFPB. So they did it in addition to the federal agencies that were already there and the state agencies that were doing it, because we didn't think that we had enough hammers hitting enough nails. We saw it in OSHA. I mean, OSHA should be protecting workers from getting hurt in the first place, not showing up after somebody's been hurt and dinging somebody. I mean, sometimes that's necessary, don't get me wrong, you got bad actors and they got to be fined. But if we could work with those businesses, and I've represented in my law practice small contractors, they're not always as togged out as you are, Mr. Odendahl, and they need some help. It'd be great for OSHA to get in there and work with them to show them what they can do to make their workplace safer so that nobody's injured in the first place. I heard some interesting things said about the cost or the value of a human life. You can't put a value on human life, let's just face it. But we try to. In various jurisdictions around America under wrongful death laws, we have judges and juries that try to do it all the time. It's about as imperfect thing as you can see, by the way. Nobody would say that that's the way to do it. We can make an automobile that basically reduces to zero your chances of being hurt in an accident. And not a single American could afford that automobile. We have to make these trade-offs all the time. And there are human lives involved when we make those decisions. But it's part of the practicality, the economic practicality of living in the world that we have. Unfortunately, during the Obama administration, they took the philosophy that because they couldn't get Congress to do the legislating, they were going to do the legislating. And so you had things like this Department of Labor effort on the overtime rule that exceeded the statutory authority where we had delegated our legislative power to them. And the court said, no, you can't do that. And it did it in a number of different ways. So it seems to me it's better off if Congress does our job. And our job is to do the legislating, not the regulatory agencies. We've not done a very good job of that in this area. Mr. DeSaunier, I was listening to you. We've not done a very good job about that because everybody's gotten their corners. You can't somehow seem to come together and talk about these things. Many of these laws that we're talking about were written in the 30s and the 40s. The workplace of the 21st century doesn't resemble that era. We should be able to get together, Democrats and Republicans, and talk about how these laws and the regulatory environment make sense. Forget the employers for a second, for the people that work there, because they obviously don't make sense in certain situations. I've been watching certain data for some time now. The percentage of people in America who work in unionized environments. The Obama administration was probably the most union-friendly administration that we've seen in decades, and yet union membership continued to decline. Why? Well, the most simplistic way to respond to that is what they're selling, workers ain't buying. But why are they, what is it they're selling they're not buying? They're selling something under a model that made sense in the 30s and 40s and 50s. Doesn't make sense anymore. That doesn't mean there's not a place for unions. It doesn't mean there's not a place for us to think about what that relationship is. But we haven't rethought the National Labor Relations Act in decades. We haven't really sat down and thought about what we can do with all the things we've learned since OSHA was passed, about having a better understanding under the statute about how employers who probably know as much more about workplace safety as the OSHA people do, from my experience, how employers can work with OSHA in a symbiotic relationship where we're doing the thing we ought to be doing, which is to do everything we can to make workers safe. I'll ask that question of Mr. Holtz-Eakin because I always think about these things. How am I going to explain this at a town hall meeting? And I want you to come with me to a town hall meeting in Grand Bay, Alabama, where they are asking me questions, and somebody may ask me a question about this. And I've got to be able to answer it in a way where I can understand it, so I can speak to it in a way to where they can understand it. And it seems to me it comes down to this. If we put unnecessary regulations out there, and that imposes a cost burden on employers, employers have less money at their disposal to increase wages and benefits for their workers and to create new jobs for more workers. I think that's what it really comes down to. So it's in everybody's interest to have the right regulatory environment that does accomplish those things that the American people want, like workplace safety, like an environment that's free from discrimination, at the same time not imposing the costs on employers that puts them in the position where they can't pay higher wages, where they can't offer the benefits that they want. I mean, there is a problem with wage stagnation in America. I mean, it's a big problem, and I think it drives a lot of other problems, frankly. And I'm hoping as this economy keeps chugging along that we'll start seeing wages grow more, but we hadn't seen it yet, and I hope that we get there. Finally, Mr. Takano talked about what the President said about standing up for the American workers. I've talked to a lot of those workers, and they felt like people hadn't been standing up for them. Some of them are people that work in the coal industry, and we wiped out their jobs. And nobody said, well, here's what we're going to do to help you now that we've wiped out your jobs. In my state, we've lost a lot of jobs that used to be in the textile industry. Those jobs have gone to Asia mostly, where they can make socks for a lot cheaper than we can in America, even when you put the transportation costs on it back. But nobody went into those people that used to make socks in northeast Alabama and said, we're now going to teach you something else to do in an industry that's now coming to Alabama that pays even better wages. We left those people behind. And they voted in 2016 because they were mad about being left behind. And President Trump got right into that and said, I'm here with you. Maybe we should all learn a lesson from that. And I think President Trump has stood up for those people. And I'll close with this. I've been going around my district since we passed the tax reform bill. And I've had the privilege of being there when an employer shows up, brings all of his employees together, and says, this tax reform bill that Congress passed has enabled us to be able to invest in our business, and so we're going to be able to buy some new machines, make us more productive, et cetera. But I also want to give some of it back to you. And when those employers give them bonus checks, and the employees look in their checks and realize the federal government's taking out less money so that they have more money in their pocket so they can make the decision about how they're going to spend their money and not somebody in Washington make the decision for them. I think those people feel like President Trump and Congress is standing up for them in that environment. But this committee and the Congress as a whole should never, ever rest and always do whatever we can to stand up for the average American worker. And with that, we'll bring this hearing to conclusion. Thank you. We are adjourned.